Hi, my name is Maureen May. I am a registered nurse. I am also PASNAP president. I have been working at the bedside as a frontline healthcare provider for over 36 years, and I work in an acute care facility. This is an incredibly challenging time for healthcare workers and probably the greatest challenge of my career, having faced this awful pandemic. Simply reporting to work as a frontline healthcare provider at this time of COVID can be very risky and can mean gambling your life as well as the life of your loved ones. That's why PASNAP sponsored a program and webinar just a few weeks ago on self-care. And tonight we're hosting tonight's webinar with the Lehocky, Lehocky law firm on workers' rights. Across the country, workers are facing varying COVID rules, whether COVID's covered or not by workman's comp. Is it a workplace injury or is it not? But more than a dozen states have changed their rules and their laws since the pandemic, kind of shifting the burden of proof from the employee and putting the burden of proof on the employer. Unfortunately, Pennsylvania is not one of those states. However, Bucks County State Representative Frank Ferry, who is a friend of PASNAP and has recently attended St. Mary's informational picket just 2 weeks ago, has introduced a bill that would help frontline healthcare workers that have contracted COVID qualify for workman's comp, but it still remains bottled up in committee. In a pandemic, when you're told to go to work and when you go to work and you're more likely to be exposed, how should the workman's compensation system work? And how should we respond in that system, and what should the workman's comp system look like? And those are just some of the questions that our guests will help us answer tonight. Jerry Lehocky and Thomas Giordano Jr. are partners at Pond Lehocky, the largest workers' compensation and Social Security law firm in our region. And Tom Giordano heads the firm's Social Security Disability Department. And under his leadership, the department has secured benefits for more than 38,000 people in all 50 states. Jerry is a former chair of the Pennsylvania Trial Lawyers Workmen's Compensation Section and has served as a consultant to several Pennsylvania governors, state representatives, and senators on workmen's comp issues. In 2006, Jerry co-sponsored, or co-authored, I should say, legislation in favor of worker injuring workers, which was the first piece of legislation to become a law in Pennsylvania in over 30 years. And as a personal plug to Mr. Jerry Lehocky, I have to do this.
All right,
but
go ahead.
I had met Mr. Lehocky after I had a workers' comp injury, which I didn't know was at the time. And I had a insurance company that was not going to cover an MRI and said, this is probably workman's comp. I went to a workers' comp attorney who said, you don't have a case. I went to Mr. Lehocky who said, you have a case, and we did win that case. So that, on a personal note, thank you, Jerry, for that.
You're welcome.
Thanks. Mr. Lehocky and Mr. Giordano designed this webinar specifically for PASNAP and the members to inform us of our rights during this unprecedented time. So thank you, and we appreciate you being here for us tonight.
Thank you, Maureen. Good evening, everyone. With my partner, Tom Giordano, we're going to spend some time tonight talking to you about workers' compensation, Social Security disability, and the interplay of those two areas of law and COVID-19, particularly for the PASNAP membership who work in various departments in facilities all throughout the Commonwealth, some directly on the front lines taking care of patients who have contracted COVID-19, and others who don't necessarily work on those front lines, but are in departments and facilities with workers who are on those front lines and may come in contact with them. I'm going to start off by talking about workers' compensation, and then we're going to lead into Social Security disability. First and foremost, I want to make it very clear that if you are an employee for any facility in Pennsylvania, not just necessarily a PASNAP facility, and you come in contact with a co-employee who has COVID-19, or a patient who has COVID-19, or a resident in a long-term care facility that has COVID-19 and you contract that virus while at work, that is a work injury. That is covered under the workers' compensation laws of Pennsylvania. It's to be treated like any other injury in Pennsylvania. No different than if you lifted a heavy patient and blew out your back or blew out your shoulder or your knees or your hips. When you do find out that you've contracted COVID-19, you've tested positive, you have an obligation to notify your employer that you believe, if you do in fact believe you contracted it at work and nowhere else, to have your employer begin a workers' compensation claim on your behalf. And what that means is that you need to go to one of your supervisors, let them know that you believe you've contracted COVID-19 while at work and that you want to have an injury report completed and go through the normal workers' compensation process. That process involves the completion of an injury report. It then involves an obligation by your employer to notify its workers' compensation insurance carrier that you're pursuing a claim. And you then are obligated to get medical care to take care of that. Now, with respect to this virus, what we know from the CDC and the Commonwealth of Pennsylvania's guidelines is that once you are tested positive, you are obligated to quarantine, which means that you're not permitted to go back to work at least for 14 days originally. Now, I was on the CDC website today, and the most recent information is that the time period for being contagious is now about 10 days, as opposed to what we originally thought was 14 days. The federal government and the state, through the state through the federal government, has provided COVID pay for 2 weeks for most employees in Pennsylvania who contracted COVID and who can't work. And that, for the most part, has taken care of 90% of the patients or employees who've contracted COVID. You go through your 14-day quarantine, assuming that you're not severely symptomatic. You come out of the quarantine. Hopefully you have an immunity at that point. You have an antibody that you may want to share with someone down the road. But you're at that point able to go back to work, assuming that you no longer have symptoms and you're physically capable of working, which is very important. Look, like any virus, any disease, any injury, everybody reacts differently to it. If your symptoms continue beyond 14 days and you are unable to perform your job, then your claim is going to continue. Now, what we've seen happen, for the most part, workers' compensation insurance companies are acting like workers' compensation insurance companies, and they are denying these claims. Now, we've had some that have been accepted at certain hospitals, but for the most part, they're being denied. And our law firm in particular, we must have spoken to thousands of healthcare workers since March regarding COVID-19, contracting it at work, what their rights are, et cetera. For those workers whose symptoms, whose problems have continued beyond the 14 days, that are serious and who can't go back to work and are fairly certain that they've contracted it at work. Now, remember, at some point, we're going to have to prove that you have contracted it at work, which is not an easy task, believe it or not. But for those of you who work on the front lines, those of you who are taking care of COVID patients, and you contract it, and you have a serious medical condition as a result of that, I'm going to take that case. We're going to represent you. We're going to fight the insurance carrier. We're going to fight your employer, and we're going to get you the benefits that you're entitled to receive under the Pennsylvania Workers' Compensation Act. And those benefits include having your medical treatment covered by the workers' compensation insurance carrier, and you're being paid a benefit rate based upon your wages for as long as you're not able to work. Now, Maureen alluded earlier to some proposed legislation that currently is still bottled up in committee in Pennsylvania. There are 3 or 4 pieces of legislation that have been proposed in Pennsylvania since March. For the most part, they all basically say the same thing. And that is, if you are a frontline healthcare worker, if you are a policeman, if you are a fireman, if you are someone who works in a long-term care facility who's housing patients or taking care of residents who have COVID, and you contract it, these proposed pieces of legislation give you the presumption that you got it at work, so that you don't have to prove that you got it at work. All you have to do is prove that you got it. And that very strict or very high burden is taken away from you. And as Maureen said earlier, the burden then shifts to the employer to prove that you no longer have it, or you're sufficiently recovered to go back to some kind of employment. Whether or not these pieces of legislation ever get passed remains a mystery. And it all depends, honestly, on how long this pandemic continues, whether it gets worse. If it slowly goes away, I don't foresee these pieces of legislation being passed, honestly, but anything can happen in Harrisburg. I applaud Frank Ferry for proposing this legislation, along with the other state representatives and state senators have done that. And our firm is going to continue to push for the passage of that as much as we can, because I think it's important. There are other recognized diseases in Pennsylvania where the legislature has recognized that there's a direct connection between a specific disease and a particular worker, and that presumption is assumed. So we're going to fight for that, and hopefully it'll get it done. Now, once you test positive, you have an obligation, whether you think you're going to be out of work or not, to notify your employer. It's very important that you do that. All right. And then your employer then, as I said earlier, has obligations to go forward with completing the injury report, referring you to medical care if there's a panel list that was provided to you and you signed the acknowledgement of the rights letters. If there is no panel list that was provided to you, then you are free to treat with any doctor you want to treat with. There's no requirement that if you get hurt on the job, you're automatically forced to see an employer doctor or a WorkNet facility or a Concentra or a HealthWorks. That's one of the biggest myths in Pennsylvania workers' compensation. If you don't have if a list wasn't provided to you and you didn't sign the letters, you're free to treat with anyone you want at your convenience. We get a lot of questions on how does FMLA and the ADA apply to this kind of situation. The Family Medical Leave Act is a federal law that allows an employee to take up to 12 weeks of leave where your job is protected during those 12 weeks. That leave could be for medical reasons, it could be for personal reasons, so long as you have been employed at a certain amount of time in the year before then, and your employer has at least, I think it's 50 employees to qualify for FMLA. If you're pursuing a workers' compensation claim because you believe that you contracted COVID-19 while on the job, you're not required to also complete an FMLA application. You can if you want. It's not a requirement. It will protect your job, assuming you're not out of work for 12 weeks or more. Once the 12 weeks are up and you're still out of work, you're going to lose that FMLA protection. However, the laws of workers' compensation in Pennsylvania also protect your job in a certain sense, where if you're out of work more than 12 weeks, you've used up your FMLA, you're being paid workers' compensation benefits, and you're now physically capable of coming back to work, your employer has an obligation to provide a job for you, even after the 12 weeks and that protection is gone. If your employer doesn't offer you some kind of job to come back to, workers' comp is going to continue to pay you. So most smart employers will bring you back to work. So you don't necessarily have to worry about using that FMLA protection for a workers' compensation claim. The Americans with Disability Act involves protections once you assert a disability and you're seeking reasonable accommodations for when you come back. Workers' compensation kind of subsumes that. If you have restrictions as a result of a work injury and you're able to come back to some kind of work, again, the employer has an obligation to accommodate those restrictions. If it chooses not to accommodate those restrictions, they're going to pay you to stay home. All right. If it does, then you can assert an ADA protection along with workers' compensation, but normally those rarely mix. The ADA typically involves someone asking for an accommodation for something that was non-work related. All right. There's a question here, do per diems qualify for workers' compensation benefits? Absolutely. Part-time workers qualify for workers' comp. Any employee, whether you work an hour a week, an hour a month, or 100 hours a week, you automatically qualify for workers' compensation benefits the moment you become an employee. There's not a requirement you have to vest a certain amount of time in order to be protected under the Pennsylvania Workers' Compensation Act. The moment you become an employee, the protection of the Workers' Compensation Act applies to you. There are differences in benefits with respect to workers' compensation and, let's say, short-term disability, long-term disability, those kinds of benefits. Short-term disability, long-term disability typically are for non-work related problems. And for the most part, particularly with healthcare workers, you're going to get more money on short-term disability and long-term disability than you would on workers' compensation. In Pennsylvania, what you receive under the Workers' Compensation Act is based upon what you earned in the year prior to your work injury. It's a complicated mathematical formula that I don't need to get into right now, but for the most part, you can expect to get around 2/3 of your gross wages. But I can tell you that most PASNAP union members make far more than the statewide average weekly wage, which means that you're going to be capped at the max for Pennsylvania. And for the year 2020, that's $1,081 a week in non-taxable weekly benefits that you would be paid for as long as you're not able to perform your job. Let's see what else we got, Tom.
There you go.
Okay. What are employers allowed to disclose about an employee's health? Are they required to alert staff about possible coronavirus victim? Well, clearly your employer has to provide a safe workplace. Those are the OSHA regulations. And if someone in your unit tests positive, you're required to be told about it. You may not be required to be told their name, but you're required to be told that someone in your unit has tested positive, and there's certain obligations that the employer then has to do vis-a-vis that area. For example, if someone came back to the law firm working, tested positive, we would then, as an employer, be obligated to make everyone who worked around that person quarantine along with them for 14 days, find out who came in contact with them in the past 48 hours, ask them to quarantine themselves as well. There's a whole set of regulations that OSHA has set forth with respect to what employers are required to do once someone tests positive. I already talked about what someone gets paid. What's the timeline of waiting to get workers' compensation benefits? Great question. The answer to that question depends upon what your employer and its workers' compensation carrier does in response to your reporting a work-related contraction of coronavirus. The law in Pennsylvania gives your employer and its workers' compensation insurance carrier 21 days to investigate your claim, which means that during those 21 days, you're basically in limbo until you learn from the employer and its carrier whether your claim was accepted or denied. If it's accepted, you're going to get paid dating back to the time you were first stopped working as a result of the virus and going forward, assuming that you were out of work more than 14 days. If you were only out of work a total of 14 days, then under Pennsylvania law, you're going to get paid from day 8 to day 14. So you have to be out of work basically 14 and 15 days to get paid for the first 2 weeks under the Workers' Compensation Act. But as I alluded to earlier, the federal government has provided money to employers to pay for the first 2 weeks. So those weeks typically are covered under a federal act. Does HIPAA prevent my employer from notifying me of exposure risks? No, so long as the employer isn't giving up personal medical information, including someone's name, that kind of thing. But your employer has an obligation to, as I said earlier, provide a safe workforce and let you know if someone in your unit has contracted it. If you've been in contact with them, you're required to quarantine as well. But I can tell you that not all employers are doing this. Not all employers are providing the appropriate protection. It's hit and miss for the most part. If you believe your employer isn't following OSHA guidelines, you have the right to report them, and you can do that. And hopefully OSHA will come in and educate the employer and require the employer to do the right thing under the federal guidelines. And if they don't, the OSHA and the federal government will take appropriate action. So you shouldn't have to worry about it. But if you're concerned that you believe you're not in a safe environment, I would contact OSHA. What do we got next, Tom? All right. So let me segue into Social Security disability for Tom. We've had several cases within the firm since March of healthcare workers who have contracted coronavirus and have become severely symptomatic and have been left with major medical problems ongoing. They range in age, for the most part, beyond 30 and above. We haven't seen anyone really under the age of 30 with any kind of severe problems as a result of contracting the virus. Not to say that's not a possibility, but we haven't seen it with respect to the people who've contacted our firm. But if you are over the age of 50, you've contracted the virus at work or even not at work for Social Security purposes, and you're out of work for an extended amount of time, you also have the right to pursue Social Security disability in addition to workers' compensation. And I'm going to let Tom take it from here.
Thank you, Jerry. And Maureen, again, thank you for having us. It's an honor to speak to everybody. What you're doing right now during this time is just the definition of courageous, and just proud to be on this conference today. So let's talk about Social Security disability. And before I answer those questions that are on the screen right now, I think it's important to take a step back because there's so much misinformation out there about what is Social Security disability. And very basic, every one of us who collects a paycheck, 6.2% of that paycheck is going away, right? If we're paying it, it's called FICA taxes. We know it gets taken from our paycheck, but we don't always know what it's being taken for. And also our employer is matching that 6.2%. So 12.4% is going into a trust fund, and it's going into the Social Security trust fund, and it's going to buy, it's really paying for three things. Social Security retirement, which I'm sure most people on this call know about. At 62, at 66, or at 70, you can retire and start collecting Social Security. That's easy. Medicare, we all know what Medicare is, especially in the health industry. At 65, you become Medicare eligible, you get Part A, you get Part B, then eventually maybe C and D. But then there's a third part of what you're paying for out of that 6.2%, and it's this Social Security disability that is in your name, that you've paid for, that is there for you at any age, should you be out of work for any medical condition at all. And I think Jerry touched on this a little bit. This is the major difference between workers' compensation and Social Security disability, where Jerry and our workers' comp team has to prove that the injury happened in the course and scope of your employment. When you come into my world in Social Security disability, causation doesn't matter. So it doesn't matter, and COVID's the hot topic, so we'll stay on COVID. It doesn't matter if you contracted COVID in a hospital, at home, at Target, it just doesn't matter. We're not worried about that. We're just worried about, number one, do you have medical conditions that's making it difficult for you to work? I think the other major distinction I want to make, and Jerry started to allude on this as well, is if you contracted COVID, and I'm obviously not a doctor, but what I know is that a majority of individuals who contract COVID, after that 14 or more days, you're going to start getting back to some sort of baseline and get back to work, hopefully. Those individuals, and I think we know that if you have certain comorbidities, it becomes more difficult to get back to work. Those individuals who contract COVID and are unable to get back to work, like Jerry said, this is a absolute viable option for you. And that's important. But I think it's also important for any of the medical providers, any of the nurses who are on this call right now, that let's talk about conditions outside of COVID. Let's assume you are and we're using 50, and I always have to give this caveat. We're not suggesting that if you're 50 years old or older that you're old, okay? I promise I'm not suggesting that. But the rules of Social Security are such that it gets a little easier for you to prove disability if you are 50 and older. So we pick on you 50-year-olds and older, but it's just because it gets a little easier to prove disability. So if you're a 53-year-old nurse and you have been dealing with bad back, bad knees, shoulder pain, all physical conditions that may be related to the work that you've been doing, or maybe you're dealing with conditions like diabetes that have absolutely nothing to do with your work, heart disease, any medical condition whatsoever, if it's making it difficult for you to work and causing you to either miss time or stop completely, I want you to consider Social Security disability. You've paid into it, it's there for you, and you can receive up to $3,000 per month in disability benefits if you simply prove that you can't do your job anymore. So that's important to know. So here's question number one on my slide. What is the right time to apply for Social Security disability during this pandemic? So that the number one rule when it comes to a disability claim is you either have to be out of work completely or earning less than $1,240 per month. So most of the individuals on this call, you're going to be earning more than $1,240 if you're back to work. So let's just focus on the people who are out of work. You have to be out of work to apply for Social Security disability. Now, would I suggest that you apply for Social Security disability if you have the COVID symptoms and that's it, and you expect that once they run their course, you're going back to work? The answer is no. I wouldn't suggest you apply for it in that scenario. Where I would suggest that you consider Social Security is if, whether it's COVID related or not, you are out of work because of some medical condition, no matter what the cause. Okay, I mean, we know how physically demanding your jobs are. So if there's any condition that's causing you to not be able to do that job, that is a disabling condition in the rules, under the rules of Social Security. Is it possible to qualify for SSD and then return to work? Absolutely. What I really like about this program, no matter what your age is, if you are found disabled from the Social Security Administration, you can return back to work at any time. In fact, they encourage it. They give you something called a trial work period, where if you're on disability benefits, they will continue to pay you Social Security disability while you attempt to return to work. And they will actually pay you for up to 9 months while you attempt to return to work. So what are they doing? They're encouraging you to try to work while still paying you. And if within that 9-month period you can't work and you have to go back out, you'll keep getting your Social Security benefits. So I don't want anybody on this call, and by the way, I don't know if this is a call, it's a Zoom, right? But on this call to think that if they go out of work on disability, that it's a lifetime sentence of disability. It's absolutely not. It's can be as short or as long as you need it. Now, some people, maybe a majority over 50, will be found disabled, and then we'll take that disability all the way to their full retirement age of 66. And then when you hit 66, your disability automatically converts to retirement. Why is that important? Because then you become considered, you're really considered retired at 66 and not disabled. Other than COVID-19, what are some of the disabilities Americans are at risk for when returning to the office? If we're going to be specific about COVID, I think probably the biggest thing that most individuals are dealing with right now is anxiety. So I can't imagine what it's like to go into work every day and put yourself at harm. You know that there is an absolute chance that you are going to contract COVID. I have to think that's going to cause some anxiety. I have to think that's going to cause some real fear that may manifest itself in depression, etc. So if that's happening, that absolutely would be something other than COVID-19 that I think could be considered a disabling condition. But again, remember, if you're out of work because of COVID and you have other medical conditions that are keeping you from returning, not COVID, then that's also considered a disability. So I want you to consider Social Security there. How do I know if I qualify for Social Security disability? There's a real easy test that we use, and we call it the 5 out of the last 10-year rule. A rule of thumb is if you've worked and you've paid taxes, you've paid into Social Security 5 out of the last 10 years, you're going to qualify for Social Security disability benefits. For some of you, you may remember a time, and this is probably in the last few years this changed, that you would get something in the mail from Social Security called your yearly earnings statement. They stopped mailing them out because it was costing the government too much money. So now they want you to access it online at ssa.gov. But you would see your earnings accumulate from all the years that you've paid into the system. So if just assume that you've worked 5 out of the last 10, you'll know you're eligible. If you want to know today, if you want to know right now if you're eligible for disability, then go on to Social Security's website, which is ssa.gov, and there's a My Social Security tab. You click on that, it'll say download my earnings statement. You're going to have to answer a lot of personal questions. That's one thing Social Security Administration is really worried about, and that's Social Security fraud. So they'll have you answer 100 questions. You fill out some forms, and then you will have access to your earnings statement, and you'll know if you're eligible for disability. But again, if you've worked 5 out of the last 10 years, it's an easy assumption that you are. If I continue to work longer, does that increase the benefits I receive from SSD? Yes, absolutely. So every year you pay in, assuming you're making more money that every year you're paying in more, you're going to have a higher benefit. Now that benefit does get capped. So after a while, you're not going to receive more than a certain amount of money. And every year it goes up a little bit. I think this year, the max of SSD is around $3,200 a month. So that's important. Now, there was a question on Jerry's slide, whether you can, or I don't know, maybe I'm making this question up, but can you get workers' compensation and disability at the same time? The answer is absolutely. And I would suggest that many of the nurses that we deal with, if they're out of work, this is where Jerry and Sam Pon, our partner, this is where I think, not to give us a plug here, but we separate ourselves from maybe other workers' comp attorneys in the state. If you're with Jerry and you've been out of work for a certain amount of time, Jerry's just going to know instinctively that it might be time for you to apply for disability. And he'll send me an email and say, hey, I want you to speak to this client. He or she's on workers' comp. Let's apply for disability for them. We'll do that. You can receive workers' comp and Social Security at the same time. There's a lot of benefits to doing that way. We can spend a lot of time on that, but just know that if you're out on workers' comp and you're listening to this call right now, and you've been out for, I'd say, anywhere close to a year, you should always consider applying for Social Security disability. So email us if you have any questions about that, if you are out on workers' comp right now. How long does it generally take to receive Social Security benefits after applying? So this is a pretty big topic. In the past, it could take up to 3 years for an individual to start the process before he or she is found disabled. It's gotten better. That's one thing that's the positive, but it still can take a while. Everybody goes through the same process. So the first thing you have to do, no matter what state you live in And the good thing here is, I know we're dealing with Pennsylvania, but if you live in New Jersey, if you live in Maryland, if you live in Delaware, if you live anywhere in the 50 states, this program's the same in all. And we help you in every state the same way. It's all the same system. So you have to apply. The application's easy. I think the application probably takes us over the phone 30 to 45 minutes to complete. Once the application is sent to Social Security, that's where the delay starts just a bit. You're probably not going to get an answer for the first 4 to 6 months after you apply. It takes a little while for Social Security to get your medical records, to make sure they have collected everything, to make a decision. 70% of first-time applicants get denied. Excuse me. So this is where you appeal. And anybody on this call who has applied and was denied, it's really important that you appeal. I'm losing my voice. I don't know what happened. Sorry about that. We never want you to give up. This is interesting, Jerry. This is a condition. I don't even know what this is. So you have to appeal. If you're denied again, then you go in front of a judge. And that is where I think we do our best work. We take you in front of a judge. We have you testify to all the problems that you have and whether you can do the job. And that's where we go from 70% getting denied to more than 70% getting approved. But if you take anything from this process, it's don't stop it. Keep it going, because that's really important. So I think that's it for Social Security. I don't know, Jerry, if there's anything you want to tie in.
No, I think we're good. Maureen, you can let everyone know if there are questions, they can email Pat directly. And I can assure you that either Tom or myself will answer every question personally within a very short amount of time. And I want to thank you, Maureen, and thank PASNAP for giving us the time tonight to reach out to your membership. And as always, we're here to answer any questions you may have. Thank you.
Thank you. I want to thank both you, Mr. Lehocky and Mr. Giordano, for being with us tonight. It was very informative, and you're always informative when we have
Thank you.
time to get together with you. Our members that have been to your law firm have been very successful. That's why we continue to stick with you, and we really appreciate you making this webinar for us tonight. And again, if you have any questions, you can direct them to the Lehocky, Pond Lehocky Law Firm, or you can go onto Facebook and or to info@pasnap.com. We will certainly forward those questions to the Pond Lehocky Law Firm. So thank you again for the
Thank you, Maureen. Thank you, Tom.
Thank you. Great to see you.
All right, good night.
Good night.